On December 11, 1860, miners deep inside the Red House colliery heard a terrifying sound. Millions of gallons of water were bursting through the dark subterranean walls of their coal mine, instantly drowning the shafts and halting operations. The floodwater came from directly above. A neighboring textile mill owner named John Rylands had just finished building a massive reservoir to power his factory. But Rylands had no idea that beneath his new reservoir lay abandoned, poorly sealed mine shafts connecting straight to his neighbor's active colliery. The contractors Rylands hired discovered those old shafts during construction and chose to ignore them. Because they were independent contractors, their mistakes didn't legally transfer to Rylands. He ordered no corner cutting, he harbored no malice, and committed no personal carelessness. A business owner had built heavy infrastructure that destroyed his neighbor's livelihood, causing nearly 100,000 pounds of damage in today's money. Yet, according to the strict letter of the law, nobody was at fault. This left society with a difficult problem. How do you compensate the innocent victims of progress when no one is legally to blame? English common law at the time required victims to fit their injuries into very specific boxes. You generally had to prove a breach of duty, which is negligence, or a direct, intentional physical invasion of property, known as trespass. The ruined miner, Thomas Fletcher, was caught in a legal trap. He couldn't sue for trespass because the flooding was an indirect accident, not an intentional invasion. And he couldn't sue Rylands for negligence because Rylands was completely unaware of the abandoned shafts and therefore legally blameless. The legal deadlock over this flooded mine exposed a massive gap in the system. The traditional fault-based framework was unequipped to handle the scale of indirect damage unleashed by the heavy machinery and massive infrastructure of the Industrial Revolution. Fletcher refused to accept defeat. In 1866, he appealed to the Court of Exchequer Chamber, bringing the case before 6 judges who held the future of civil justice in their hands. Speaking for the court, Justice Colin Blackburn delivered a ruling that reversed the earlier decisions. He officially severed financial liability from moral fault, agreeing with the spirit of Bramwell's dissent. Blackburn's standard: anyone who brings onto their land something likely to do mischief must keep it in at their peril. If that hazard breaches the boundary, the owner is prima facie answerable for all damage, accepted as correct until proved otherwise. Rylands appealed one final time to the highest court in the land, the House of Lords. In 1868, Lord Cairns affirmed Blackburn's strict standard, but he added one critical limitation to prevent the rule from applying to every minor accident. Lord Cairns introduced the requirement of non-natural use. The rule would only apply to special, extraordinary, or highly dangerous uses of land, like building a massive commercial reservoir, rather than ordinary domestic activities, like installing household plumbing. A landowner was now financially responsible for the hazards they created, even if they took every possible precaution. Engaging in heavy industrial activity meant accepting the peril of paying for any resulting destruction. Over the next 150 years, courts in England and Wales kept the rule from Rylands versus Fletcher alive, but they steadily chipped away at its power to protect modern industries from infinite liability. In the 1994 Cambridge water case, the House of Lords ruled the specific damage must be reasonably foreseeable. A chemical spill that contaminated a distant borehole decades later was deemed too unpredictable to trigger liability. A decade later, the Transco precedent narrowed the definition of non-natural use to only truly extraordinary risks. The court also restricted the rule exclusively to property damage, meaning victims can no longer use it to sue for personal injury. Other nations took different paths. The High Court of Australia chose to abolish the doctrine altogether, absorbing cases of hazardous escape back into the standard laws of negligence. These restrictions reveal a legal system constantly calibrating the scales. To encourage economic growth, courts have heavily insulated modern businesses, making it increasingly difficult to hold them strictly liable without proving fault. India took the exact opposite approach, following catastrophic industrial accidents, most notably the 1984 Bhopal gas tragedy, which exposed hundreds of thousands to deadly toxins. In response to these massive chemical disasters, the Indian Supreme Court forged a much harsher doctrine during the MC Mehta case. They created the principle of absolute liability. The original Rylands rule allowed defendants to escape liability if the accident was caused by an unforeseeable act of God or the malicious intervention of a third party. India's absolute liability strips away all of those defenses. If a hazardous enterprise causes harm, they must pay, with zero exceptions. The flooding of Thomas Fletcher's coal mine forced the courts to answer a difficult question about the cost of innovation. As technology grows more complex and the potential for destruction scales up, the privilege of profiting from that progress demands a guarantee to make the victims whole.